start at this time. Thank you. At this time, we're on record in Weitz versus Weitz, matters before the court for oral argument on behalf of the appellant, Mr. V.K. Smith, on behalf of the respondent, Michael Rowe. Any preliminary matters by either party?
We have none, Your Honor.
Thank you, sir. Mr.
Oh,
Rowe?
thank you, Your Honor.
Very good. Mr. Smith, you may proceed, sir.
Thank you, Your Honor, and may it please the court. This appeal concerns the lower court's grant of a summary judgment, when in fact we believe that there existed genuine issues of material fact that required this case to go forward with the trial, and the lower court erred in its grant of summary judgment as it has done. So what I intend to do this morning before you justices is explain to you what I believe the record reflects to be among the genuine issues of material fact and the reasonable inferences from which a summary judgment should not have been granted. The Weitz family has a number of entities. Two of the primary entities that they had was the Idaho Farmway, which I'll refer to as IFI, and also Treasure Valley Manufacturing and Recycling, which I'll refer to as TVM. The IFI Corporation was the father's. His name was Phil Weitz, but he ultimately gave the stock interest in IFI to each of his three sons, being Daniel, John, and David Weitz. In 1987, the father, Phil, and a gentleman named Joe Zaccaro wanted to get together and put together a junkyard salvage operation. So the oldest son, Daniel, formed the corporation, TVM, in 1987. And when he did that, he then issued 3 certificates of stock, one to each of the brothers, and then retained the remaining 25 shares in treasury stock. There was 100 shares of capital stock authorized, of which they issued only 75 shares. In certificate number 1, it went to Daniel, 25 shares. Certificate number 2 went to John, 25 shares. Then certificate number 3 to David, 25 shares. What progressed in the course of time is that IFI did the potato raising contracts with Simplot. And by 1995, Simplot then lost their French fry contract, and Ore-Ida took over much of it. Consequently, there was a significant transition in the operations of IFI. And at that time, Daniel was the primary manager of IFI, and David then was in the shop of IFI working on equipment. So the father, who was actually the patriarch of the family, he basically directed what the sons did. So he directed Daniel to stay with IFI and work with Phil and leases and operations of all the ranches, the farms, and then had David come on over with Phil and Joe Zaccaro and John Weitz to participate in the operation of TVM. Basically, David went into the shop where he then continued the manufacturing or repair of equipment. So from 1995 on, we have David with TVM, and we still have Daniel with IFI. Now, what they did each year, they had Christmas dinner at the parents' house. So while at the parents' house, they had their annual stockholder meeting on both of those corporations. They, in essence, were the sole shareholders in IFI and TVM, that is the brothers, and therefore they elected and re-elected themselves each year as the directors. And they might shuffle around who's going to be what officer of what. But bearing in mind, the father, Phil, ran the show in all instances. He's the patriarch, and we all agree with that fact. So we have a clear understanding, a clear, genuine issue of material fact that we had 3 certificates of stock, 25 shares each, and we had annual meetings every year at the father's residence during Christmas. So that goes on uninterrupted, where each acknowledges The brothers are the shareholders. The brothers are the stockholders of these two corporations. So now we get into about 2009. The father, Phil, gets cancer. Diagnosed, it's progressive. It's ultimately terminal. So we have David in TVM, basically he's taking over more of the management instead of Phil, being more controlling on the financial documents instead of Phil, depositing funds, as the record reflects, into PCNS, another entity owned by the father without the father's knowledge, coming out of TVM. So we have David operating that, and we still have Dan operating IFI. That goes on. The father then dies in 2013, March 24, 2013. It's a shock to everybody, but they knew it was coming. So the brothers meet. Daniel lives in Baker City, Oregon. David lives basically in the Caldwell area, about a mile or so from the father's residence. So they meet on March 25, 2013. The purpose is to decide, what are we going to do from here without our father? So they meet, the three brothers. They confirm what assets are in the house. So there was significant financial value of assets, over $1 million in gold, over $1 million in cash, 8,500 troy ounces of silver, all kinds of family heirlooms and valuables. They confirm that's all there. David confirms, because he's local, I'll take care of it all, I'll secure it all. And they then have a meeting. Now it's their meeting on, once again, the two corporations. They determine, yes, we are the only stockholders. And yes, we will continue to nominate ourselves as the only directors. They determined that Dan Weitz would be the president now of IFI perpetually, and David would be the president of TVM perpetually. So what we have at that point in time is a clear understanding. By 2013, everybody agrees. Daniel, John, and David Weitz are the sole stockholders and the directors of those two corporations. Now, what happens, we begin to progress into a developing hostility among the brothers. We no longer have Phil. The truth is, Phil was the glue. He kept the family together. He orchestrated who did what. And he basically ran the show. So now we have David, who is the middle child, deciding he kind of wants to run the show. He was made the personal representative. Originally, it was supposed to be Daniel to be the personal representative, but because Daniel lived in Baker City, Daniel suggested to his father he make David the personal representative. So David was listed in the will as such, and he ultimately 7 months later was appointed as such. But many things were happening from March 25, 2013, as the days and weeks and months progressed. Within 3 days, David had taken over the PCNS, the corporation out of Nevada that belonged solely to the father, listing himself as the owner and his wife Katie as an owner. What then happened is the gold disappears, the silver disappears, the cash disappears, and all the records and files which the father kept disappears in possession of David. Dan doesn't have it, John doesn't have it. So the hostilities develop. So what then progresses in the course of time is, because David is now the personal representative in the estate, he gets with Val Dilley, his accountant, and they put together what is referred to as the August 25, 2015 summary report. Now, this summary report is very significant because it's created in the backdrop of the estate, but within that document is reference to TVM. Now, TVM is not owned by the estate. The estate had no interest in TVM. Phil had no stock interest. The brothers owned it. So what David does in that particular document is he enters a reference to his two brothers that he wants to own the stock in TVM. and he offers each of the brothers right at $31,000. Actually, it was $30,969.90 each to be paid to each to buy their shares of stock. What did
Sir,
he base that upon?
excuse me, just one second. Sir, excuse me. I have that document before me, and I don't see in the writing where it says anything about an offer to purchase, as opposed to a net equity of TVM being 92,919, and then the 1/3 equity for each brother. But I don't see in that document where there is an offer to purchase. Was
Well, there
it
is
in another document, or is it oral?
Well, there is in the record documentation. It was attached as an exhibit, which reflects that portion of that page taken out of that summary report that identified what he wanted, and he wanted their stock interest. Now, what's interesting and what's important also in the summary report is submitted with it was the certificate number 3, which is the 25 shares that went to David. He did not include certificate number 1 that went to Daniel, nor certificate number 2 that went to John, just certificate number 3. He then included 2 additional certificates, 5 and 6. 4 had been long ago canceled. 5 and 6. 5 was David wanted John and Daniel to endorse that document to give to David their 50 shares. And certificate number 6 was the one they wanted them to sign that would give to John Tavares 25 shares, which would have been the 25 shares of the treasury stock. So what we then know at this point in time is that David acknowledged that his brothers had their shares. He's trying to divide or issue money to them, $30,969.90 to each, based upon the 1995 net valuation. Now, why did David pick 1995? Well, that's the year that David came over to TVM from Idaho Farmway, IFI. And he became there, and he was a fixture. He was a permanent part of TVM. But he got a salary. He was paid. He got a monthly salary. So he was an employee as well as an owner. But David felt he wanted to control it, and he wanted the 2 brothers out, and he'd pay them a little bit of money to do so. Now, when Daniel and John received that summary report, Daniel wondered about that valuation, and he went to Val Dilley, because Val Dilley was the accountant that David had in the estate. And Val Dilley knew that Daniel and John were stockholders. So Daniel went to Val Dilley and said, let me see the 2015 tax return, because this summary report was submitted in August of 2015. So Val gave him the tax return, and there in the tax return, it showed the net value of TVM to be over $16 million. So now here we are, a brother, Dave, proposing to buy the stock interest of his 2 brothers for right at $31,000 each, when their stock interest is worth over $5 million each. So Daniel and John got a little irritated and a little upset with their brother, and they declined to sell anything. And they, in fact, then decided they're going to challenge David's position as the personal representative and filed a petition to remove him. And that created further hostility, further controversy, at the effect of which they went further and further apart. So time goes on. So now we have, in 2018, ultimately, David decides he's going to file suit. He's going to file suit to try to get rid of his 2 brothers out of TVM. So he does so, and unknown, and at that point in time, John and Daniel unite. They have a united front against their brother David. And so they have me represent their interest. And time goes on in this TVM litigation, which is the case now before you. And there begins then to be an interesting event developing. And that event is that in December 19 of 2018, John has a meeting with David, unbeknown to Daniel or their attorney. And in that meeting, David proposes for the first time, knowing that, my God, I've got to get control of this stock. I got to get control of TVM. I don't want to run the risk that I might lose it in a battle with my brothers. So he agrees to pay now to John. And John is the youngest son. John was totally dependent upon the parents for his subsistence. He worked in TVM, had before worked a little bit in IFI, but he was a fixture also in TVM. But what David had done is cut him out of TVM, just as he'd cut out Daniel basically after the father died in 2013. So now, for the first time, John is offered by David $2.1 million to buy what? His stock interest, his 25 shares in TVM. Now, bear in mind, this is the action where David alleges that he owns the stock that Daniel and John claim to own. But now we have David proposing to pay John $2.1 million. Now, yes, it's a lot of money, but it's less than half of what the equitable value of John's interest would be. But he needed money. So John agreed to work with him on that, and he took $25,000 down payment on December 19, 2018, unknown to Dan. They wanted John to get other counsel so he could conclude. But John didn't know how to present that to his attorney or to his brother, Daniel. So it progressed on in time, March 19 now of 2019. Another $15,000 is paid on this $2.1 million deal.
Mr. Smith, could I ask a question concerning that? It seems to me that if you have two separate litigants in a lawsuit and one of them decides to settle, offers of settlement seem to be irrelevant to the cause of action. Or are you saying that the purchase by David of John's shares is a statement against interests? In other words, okay.
Absolutely a statement against interest. He alleged in his complaint he owned all the stock. He said he owned 75 shares of the stock, and John Tavares owned 25. Now, we know that's obviously not true. And we know it's not true because of the meeting they had with the August 25 summary report when he offered to buy stock that they had. So he knew they had stock. Now he's alleging he owned stock that he knew he didn't own. And now he's proposing to buy John's stock for $2.1 million and paying him $40,000 as earnest money down payment. So John will proceed with the deal. Ultimately, John does the deal. He needed money. The importance or the significance is it tells you that that complaint that David filed was a sham. It was frivolous as could be because they didn't own the stock. And now he's trying to buy the stock from John so he can control and then have 66% of the stock. He could control the corporation and cut Dan out, irrespective how the district court ruled on the summary judgment. So there lays the concerns that these are the sequence of facts and these reasonable inferences that confirm that Daniel and John had stock. Daniel had the identical shares of stock that John had. John agreed to sell out for $2.1 million. Daniel wouldn't. He said, if I'm going to sell it all, I'm going to get the $5 million. That's what I'm entitled to. So these are among the genuine issues and the disputed facts from which summary judgment should never have been entered. Now, you probably are asking, why would the district court grant summary judgment? The case is complex. The case shows a lot of hostility. There is huge animosity among the brothers, vicious accusations as to issues of credibility. But as you gentlemen know, issues of credibility are not to be considered in summary judgment proceedings. They are to look at, are there genuine issues of material fact regarding the issuance of stock and the issuance of certificates? Is there a genuine issue whether or not that stock was ever redeemed or ever sold or ever transferred? And now we know, basically in July of 2019, John transferred his 25 shares to David for $2.1 million. Now that to me is a significant, genuine issue that David acknowledged that John owned stock and that Daniel owned stock. And for those reasons, this matter needs to be reversed. Now on the issue of attorney fees, this also is fascinating because Mr. Rowe filed for attorney fees almost $300,000 on a dispute that gets resolved by a summary proceeding. $300,000. Now, Judge Southworth looked at the issue and the facts that have been in dispute and concluded there is no basis for an award of attorney fees under 12-121. There was no frivolous action by Daniel. And in essence, the court is saying he had a stock interest. And the court then denied to grant attorney fees under 12-121. But the court nonetheless then granted some attorney fees, basically $25,000, on disputes over this discovery controversy that we deny having failed to comply in any sense of the word. But that being said, the court then granted those attorney fees in relation to that issue, which was not even part of the memorandum for attorney fees. The sole issue and claim for attorney fees was 12-121. So the significance there is the judge recognized Daniel was not frivolous. He had a claim, and I believe as you read the decision from the district court, that he in fact had a stock interest. But somehow it evaporates. Somehow is it redeemed? Somehow is it sold? Somehow is it transferred? No, we know it's not. Well, that's our position, Your Honors, and I believe I'm out of time. Thank you.
Thank you, sir. Mr. Rowe?
Mr. Chief Justice, Justices, Counsel, Mike Rowe with Gibbons Bursley on behalf of the plaintiffs, respondents in this matter, David Weitz and John Tavares. With me today in our conference room is my client, Dave Weitz, and also Gibbons Bursley paralegal Tiffany Hudak. In the abstract, this case is about the legal ownership of Treasure Valley Manufacturing and Recycling, Inc. In more concrete and real terms, however, the question before us today is whether the naked claim of one man can deprive my clients of a lifetime of work when that claim is virtually unsupported by any evidence. We respectfully submit that the law does not, should not, countenance that result. Below on summary judgment and again on appeal, we've offered 5 separate bases upon which my clients can be granted relief in this matter, all equally viable. The first such basis is procedural in nature and rests on Idaho Code Civil Procedure 56C1A, which states in relevant part, quote, a party asserting that a fact cannot be or is genuinely disputed must support the assertion by citing to particular parts of materials in the record. Dan Weitz's summary judgment papers did not come close to complying with Rule 56C1. In this connection, Judge Southworth said in his opinion, quote, the 16-page memorandum is devoid of citations to the record. And subpart 3 of 56C provides that, quote, the court need consider only cited materials. As this court held in Cumata versus Ares-Mendez, 153 Idaho 609, quote, the party opposing the summary judgment is required to bring that evidence to the court's attention. Whether a motion for summary judgment goes uncontested or is fervently fought, the district court, in ruling on the motion, need not scour the record for evidence of a genuine issue of material fact.
Sir, let me ask you a question in that regard. Basically, as I went through the briefs, it seemed to me that you were arguing we had a long history of non-involvement by Mr. Smith's client, no involvement in the corporation, consistent with the stock certificate, no dividends, no pay, no anything. And as such, a totality of the circumstances comes down on your side. On the other hand, Mr. Smith is saying, we have a certificate of stock here. And and that basically is the entire issue. So why isn't that one issue? Here is my stock. It has not been in any way invalidated by the corporation. Why is that not all you need for citation to the record?
Chief Justice Burdick, with all due respect,
although here it comes.
With all due respect, although Mr. Smith might say that his client, Dan Weitz, has a stock certificate, he does not, and there is no such stock certificate in the record. In fact, the only stock certificates in the record before this court this morning shows Dave Weitz, my client, owning 75% of the company, and my other client, John Tavares, owning the remaining 25%. Ironically, as we point out in our briefing, Mr. Smith put those certificates into the record inexplicably. So I hope that answers the question, but just at the risk of being redundant, if the court finds stock certificates to be important, we have the stock certificates. Mr. Smith does not.
Very well. Thank you, sir.
Okay.
With all due respect.
Absolutely. So as I started to say, I was working on the standards for summary judgment. After the party moving for summary judgment makes a preliminary showing, the burden shifts to the non-moving party to create a genuine issue of material fact. And that's bedrock law. A mere scintilla of evidence, slight doubt, nor conclusory assertion by the non-moving party is sufficient to create a genuine issue of material fact. And that's the court in Mendenhall versus Aldis, 146, Idaho 434. Moreover, the non-moving party must satisfy its burden by citing to specific facts, not general accusations, not wholesale reference to 1,000 pages of documents. You don't have to scour the record. It was Mr. Smith's obligation to point Judge Southworth to the specific facts that created a genuine issue of material fact. More importantly, as here at the case in bar, when a matter is going to be tried to the court and not a jury, the trial judge is entitled to draw most probable inferences in favor of the moving party, in this case us, so long as those inferences are reasonably supported by the record, which we argue they are in this case. Here, Mr. Smith and the appellant failed to comply with the rule 56C and utterly failed to carry its burden on summary judgment. Accordingly, this court should affirm that summary judgment by Judge Southworth. The second basis, and as Chief Justice Burdick suggests, the one relied on by Judge Southworth below, is this idea of totality of circumstances, that when a court is faced with an incomplete corporate record, in this case over 30 years, as virtually every declarant has testified, Phil Weitz was not a great record keeper, the records weren't good. When a court's faced with that situation, it should look to the totality of the circumstances to determine ownership of the stock. As the cases we cite say, share certificates may be prima facie ownership, but they are not conclusive, either for or against. And again, in this case, I would argue we've got the certificates, so okay. But I think we look beyond the certificates. One of the things the courts always start with in the cases we've cited are stock ledgers. Fortunately, in this case, we have a stock ledger. It was dictated by Phil Weitz, the patriarch of the family, to Val Dilley, the company's CPA, in 2011 in connection with an IRS audit. And as we know, the record is clear. That stock ledger shows that my client owned 100% of this company, 75% and 25% respectively. That assertion and that argument has gone unrebutted by Mr. Smith and his client. It stands unrebutted in this record. Courts also look to tax returns for obvious reasons. I think people tend to take their tax returns seriously. And in this case, we have 14 years of tax records and all related tax documents that show unequivocally that Dave Weitz and John Tavares own this company. 14 years of filings with the IRS in the state of Idaho. This also has gone unrebutted by Dan Weitz and Mr. Smith. Likewise, the appellant has made no attempt to rebut the contemporaneous handwritten notes of volatility as dictated by Phil Weitz in 1995, 2001, and 2002. Those handwritten notes are included in our briefing and attached to Valdilli's declaration. Moving from documents to Dan's relationship, or actually lack thereof, with the company, as suggested by some of the earlier questions from the justices, Dan Weitz admits that he had no role in the company. He never worked there, not 1 minute. He didn't take 1 cent of pay. He didn't demand or attend any board or shareholders meetings. Now, I heard Mr. Smith say that the Weitz family got together every Christmas, and I guess the implication being over turkey dinner, that was a board and shareholder meeting for this company. And I'm not saying that couldn't be the case, but measure that evidence, contrast that assertion, if you will, against what we put in the evidence, which is 15 years of uninterrupted official documentary notes or minutes from board and shareholder meetings created by Valdilli. Again, they're attached to his affidavit, his declaration. So again, Dan Weitz didn't demand any board or shareholders meetings, and he didn't attend any. Dan Weitz had virtually no connection to this company other than his name. Likewise, Dan made no attempt, zero attempt, to rebut our expert witness testimony. Mike Huter, longtime corporate CPA, opined that based on his review of all available documents, Dave Weitz and John Tavares own this company. Steve Hardesty, senior corporate partner with Perkins Coie in Boise, very experienced individual, said, not unusual to have to clean up a company, recreate records. This is somewhat typical. My opinion is that Dave Weitz, John Tavares owns this company. We put that into the evidence. We put it into our briefing. Mr. Smith chose not to respond to it at all, not even to deny it, not even a conclusory statement. Nor did Mr. Dan Weitz attempt to rebut the testimony of 11 lay declarants, 11 affidavits we put into the record. What Dan Weitz did do was question the value of that testimony by suggesting those people were just simply friends of my client. They were Dave's friends. That's not the case at all. Paul Yamamoto and Dr. Richard Book were Phil Weitz's best friends in life, best friends. Valdilli was Phil Weitz's CPA long before he knew Dave Weitz. You can see Mr. Dilly's declaration for that point. So the remaining declarants include former business partners of Dan Weitz, like Jesse Prather, former employee of Dan Weitz, like Julie Vaudry. So they weren't Dave's friends. They weren't my client's friends. We didn't stack the record with our friendly witnesses. Quite the contrary. We went to people that knew Dan Weitz and his relation to this company, his claimed relation, which is zero. Now, an argument that Dan and Mr. Smith returned to repeatedly is this 2015 summary report and the settlement of these differences with John Weitz. As we put forth at sections or pages 31 through 33 of our brief, we object to the entry of that evidence as being inadmissible under Idaho Rule of Evidence 408. Both of those are settlement negotiations and settlement communications. And Mr. Smith concedes as much in his pleading, where he refers 6 times to these 2 items of putative evidence as being settlement. It should not be considered below, and they shouldn't be considered here today, and we strenuously object. That is settlement. However, if this court is inclined to admit that evidence over Rule 408, and despite the admonition in its case, Rojas versus Lindsay, where this court said, this type of evidence is of dubious value because people settle cases for all sorts of reasons that go way beyond the merits. It could be a sentiment, emotion, fatigue, economics. And secondly, in Rojas, this court said, If we admit this type of evidence, we're going to undercut IRE 408. We're going to discourage people from entering into settlement conferences, knowing that they're going to get beat over the head with it. So, to finish my thought, if the court is inclined, for whatever reason, to admit or consider this evidence, let me point out that it doesn't help Mr. Smith and his client. Neither the 2015 settlement document from Val Dilley, nor the fact that we settled with John Weitz, neither proves that Dan Weitz owns 25% or 30% of the company. It doesn't prove, it has no probative value. Specifically, if you look at Exhibit 1 to Dan Weitz's declaration and to record at page 657, this is the excerpt from this 2015 summary. You'll see that Val Dilley uses the word theorized in the second to last line. All right, so clearly what Val's saying is that he's not conceding that Dan Weitz owns any interest in TVM. He's saying you've made a claim, we believe it's specious, but to buy the piece, wrap it up as part of the estate, we would be willing to consider X. And X is $30,000 or $30,969.90 to be exact. The reason that number, as you can see, it's not based on the alleged $16 million value of the company today. It's based on what the value of Dan Weitz's interest in the company would have been in 1995. 1995 happens to be exactly the time that we claim, we think we prove Dan Weitz was bought out of this company. So what Val Dilley was saying, look, Dan, you were bought out a long time ago. Your shares were transferred, but to buy the piece, we might be willing to give you $30,000, which is what you were entitled to in 1995, if that'll do it. And as Mr. Smith said, Dan didn't want to do it. So I would argue that that piece of evidence, if it were admissible, has no probative value for Mr. Smith as the appellant. Secondly, and not to belabor the point, but the fact that my clients resolved their differences with John Weitz and settled this case doesn't prove anything. It certainly doesn't prove that Dan Weitz owns 33% of the company. They settled, two brothers settled a lawsuit. Mr. Smith suggests that the stock was purchased or there was some concession by my client that John owned stock. Not at all. The settlement agreement is not in the record. What is in the record, and I would encourage the court to review it, is John Weitz's affidavit, his sworn testimony that says basically we're telling the truth and the appellant is not. That's what that affidavit says. And I would encourage, if the court has any concerns or questions about how it is that John Weitz switched attorneys from Mr. Smith to Maureen Cassidy, I think John's affidavit will explain it, and there's probably no need for me to go into it here this morning. The upshot is that the respondents, my clients in this matter, submitted 15 declarations and over 1,000 pages of credible documentary evidence, virtually all of which went unchallenged and unrebutted by the appellant. In opposition, the appellant submitted one faulty declaration from the appellant himself, which comprising, quote, 40 pages of rambling, unsupported statements and vague accusations, according to the trial court. As such, Judge Southworth was proper to find that, quote, the record overwhelmingly supports the position that David and John Tavares are the sole shareholders of TVM. That's at page 9 of Judge Southworth's decision. The third basis upon which my clients can be granted relief in this matter revolves around the role of Phil Weitz, which has been variously described, who has been variously described in this matter as the patriarch, the commander, the paymaster, the mastermind. And you heard Mr. Smith again this morning basically reiterate and confirm that characterization. With respect to all the Weitz family businesses, including TVM, Phil Weitz had absolute control and power, and his boys deferred to him. As such, in the light of that characterization, we believe that Phil Weitz had the actual, the implied, or the apparent authority to transfer stock in TVM, conceding that at the inception, Dan Weitz did own a share of this company. His share was transferred by his father in 1995. All of the parties agree that Phil Weitz had this type of power and this type of authority. The family members agree, and the declarants that we have offered as evidence agreed. And again, in 1989, Phil used that power, that authority to transfer his 25% interest in the company to my client, John Tavares. 6 years later, Phil used that same power, that same authority, that same process, informal as it may be, to transfer Dan and John's 50% interest in the company to my other client, Dave Weitz. Such transfers were not challenged by Dan at the time, and they weren't challenged for 25 years. They were challenged when his dad died and he saw a chance to take a stab at gaining an interest in this company that he didn't own. To the extent the appellant offered any challenge in his briefing or his declaration, it was narrowly limited to just our actual authority argument. Mr. Smith and Dan made no attempt to deal with, rebut, or address our apparent authority or implied authority arguments. In fact, Dan actually bolsters those arguments in his declaration and his pleading by reiterating what we've said about Phil Weitz's power. It was almost absolute when it came to this company and his sons. In fact, at the end of Dan's declaration, he informs us that, quote, when it came to Phil, mine was not to question why, mine was to do or die. I would submit that based on that type of fealty, that at a bare minimum, Phil Weitz had the apparent or the implied authority to transfer that stock, which he did. And that's how it moved from Dan Weitz's hands to Dave Weitz's hands. Even if one assumes, for sake of argument, that Phil Weitz didn't have authority, Dan's actions at the time of those transfers in 1995 and 1989 as to John Tavares, and his actions afterwards ratified those transactions. And as the court knows, and as we've explained in our briefing, ratification presupposes that there's no authority. It basically just says that the principal, after the fact, through his acquiescence, his silence, or his actions, agrees with and adopts as his own his agent's actions. In this case, Dan was the principal, Phil was the agent, Phil transferred the stock, and over 25 years, Dan ratified that transfer. And that stands as an independent basis for relief for my clients. Not one that was relied on by Judge Southworth, but I think it's viable. Moreover, and critically, Mr. Smith and Dan Weitz have not rebutted our argument. They made zero attempt, not one word, not one drop of ink did they spill in trying to rebut our ratification argument. The fifth and final basis upon which we seek relief is estoppel. This court articulated the applicable elements in Budget Truck Sales versus Tilley, 163 Idaho 841 as follows. The doctrine of quasi-estoppel applies when, one, the offending party took a different position than his or her original position, and two, either A, the offending party gained an advantage or caused a disadvantage to the other party, B, the other party was induced to change positions, or C, it would be unconscionable to permit the offending party to maintain an inconsistent position from one he or she has already derived a benefit or acquiesced in. Now here, I would argue that we check all the boxes as enunciated under Budget Truck Sales for quasi-estoppel. In this case, Dan Weitz, the offender, certainly has changed position. In 1989 and 1995, he didn't object to or act contrary to the reality that the shares in this company had been transferred to John Tavares and Dave Weitz. That was his position then. And as we put forth in our briefing, and 11 or 12 declarants have said, Dan received plenty of consideration for the transfer of that stock. And if you think about it, and this is based on Mr. Smith's own comments, if the company was only worth $90,000 in 1995 when Dan was divested, it wouldn't take much additional consideration from his father to make him whole for that transfer. And as we see from the unrebutted testimony, Phil Weitz set Dan Weitz up in a multitude of companies, all of which failed, unfortunately, but he spent hundreds and hundreds of thousands of dollars on his son at the same time, slightly before and slightly after. Please see the declarations of Paul Yamamoto, Dr. Book, and most importantly, Val Dilley. So the point is that Dan Weitz took one position in 1995 and he's taking another position today. Okay, that's the first factor. As far as the second, number two, clearly my clients are disadvantaged by that change in position, because if it's allowed to stand, they're going to have a large chunk of their company taken from them after they spent 30 years building it. And Dan will obviously be advantaged, right? He got to keep the consideration 25 years ago, and he gets paid twice. Now he's going to own 25 or 33% of a company that he did nothing to build. So he's clearly advantaged. But most important, I think, Your Honors, is that that last factor in budget truck sales. We submit respectfully that it would be absolutely unconscionable if Dan Weitz allows to take one position, then sit on his hands for 25 years while my clients worked 6 and 7 days a week, went through an arduous IRS audit, had to do the hiring and firing and the welding and the car breaking and all that they've put in and to build a successful business that now employs 30 people. For Dan to come out of the woodwork 30 years later and say, oh, by the way, I'm your partner. That, I submit, would be unconscionable. And that's exactly the scenario contemplated by the estoppel doctrine, and one that the court could employ here if it's inclined. Now, moving quickly from our primary argument on the merits of the case to the attorney's fees and costs, with respect to Mr. Smith's comments, I would say this. Below, my clients were entitled to an award of costs and fees under the applicable rules and based on the egregious discovery abuse engaged in by the appellant. And it was egregious. There were multiple meet and confer letters, multiple motions to compel, all of which were granted. So that was justifiable. Secondly, Mr. Smith is mistaken when he said that the respondents requested their fees and his client didn't have an opportunity to respond. They did, in fact, respond to our first fee request. They chose not to respond to the second one. I don't know why. They had 4 months to do it, but that he had ample opportunity. Dan Weitz's due process rights, to the extent due process applies in that context, were not abridged. He had notice, opportunity to respond, and did respond. Finally, I would note, as an accounting matter, that on appeal, Mr. Smith and Dan Weitz are not objecting to the amount of our fee award. As Mr. Smith pointed out, $25,000, and I think it's roughly $38,000 general. He's not objecting to that. He's just objecting to the procedure by which that occurred. I would like to take a minute or two of my remaining time and address a couple of Mr. Smith's statements that maybe we haven't covered. I think we covered the share certificates. It was one of his opening arguments. Again, it's inexplicable to me, since the only share certificates in the record show my clients as the owners of the company. With Mr. Smith talked about, he used the word patriarch. He said Phil Weitz was a patriarch. And as Mr. Smith has told you, he's very familiar with this company, and we agree. He said, I found this interesting, he said Phil Weitz, quote, orchestrated who got what. In the first 2 minutes of Mr. Smith's comments this morning, he said Phil Weitz orchestrated who got what. I agree 100%. And one of the things that Phil Weitz orchestrated was the transfer of a 25% interest in TVM to John Tavares, and the transfer of 50% interest in TVM to my client, Dave Weitz. That's exactly what Phil Weitz orchestrated in 1989 and 1995. I think I talked about the Christmas meetings. That's touching, but it doesn't match up very well against the 15 minutes of board and shareholder meetings for this company that Val Dilley has accumulated and attached his declaration that show unequivocally, without challenge, that Dave Weitz and John Tavares own this company. By the way, those minutes don't say anything about, hey, Dan Weitz came to my office today and wondered why he's not getting dividends. He came to my office today and said, why don't I get paid? That isn't in the minutes. The reason not in the minutes is because he didn't own part of the company, and he knew he didn't own part of the company. Mr. Smith spent some time talking about the estate, gold and silver and bullion. I don't think it's relevant. I don't think it's necessary for me to discuss it. But if the court has any questions, I would certainly entertain the same. Mr. Smith made a comment that starting with his father's cancer diagnosis in 2009 and then his death in 2013, that all of a sudden Dave wanted to, quote, run the show. That's what Mr. Smith said. Well, that isn't accurate at all, because the record, the actual evidence, admissible evidence, indicates that my client was, quote, running the show from 1995. There's 11 or 12, depending on the account, declarations, sworn testimony from close family members, including a cousin, Kurt Weitz, his father's best friends, the accountant, Dan Weitz's former business partners, Jesse Prather, his employees, Julie Vaudry, Elizabeth Osterhout, Todd Larson, Todd Asher. Everyone said the same thing. Dave Weitz ran that company, and he runs it today. He's done it for 25, 30 years. Dan Weitz had no connection to the company. So when Phil Weitz got cancer, it isn't as though my client attempted to exploit a vacuum. That's not the case at all. He'd always run that company, and there's no real genuine issue of material fact as to that. We covered the summary report. I think Mr. Smith wanted to talk a little bit about the petition to remove in the estate. Again, not relevant to the extent it is. I would note the petition was denied. It was stricken for discovery abuse. The estate is now over. My client prevailed. In summary, I would just submit that I realize that there are a lot of people. There are a number of people involved in this case. It took place over a number of years. But what I believe Judge Southward's decision reflects, and one basis upon which this court can grant my client's relief, is the overwhelming, to use Judge Southward's conclusion, this is the record supports my client's position and does not support Mr. Smith's position. It's overwhelming. Now, obviously, this case could be different. Had Mr. Smith and Dan Weitz taken that 2 years that this case has been pending and developed their own 11, 12, 15, 25 declarations, yeah. Had they taken some depositions, had they put anything into the evidence to rebut our arguments and our evidence, yeah, there might have been genuine issues of material fact. There might have been, but that's not what happened. And that's what Judge Southward said in his opinion. It's not what might have been proven or what might have been introduced in evidence, it's what was. And what was introduced was paltry. Compounding the challenge for Mr. Smith and his client is the fact that not only did they not have much evidence or any evidence to work with, they didn't comply with the applicable rules in opposing our motion for summary judgment. They didn't comply with Rule 56. They didn't comply with the standards for summary judgment. They didn't cite to the record. They forced or attempted to force Judge Southward to scour the record. And that's not how the game is played. And that's what resulted in that summary judgment. I would ask that the summary judgment be affirmed, costs and fees below be affirmed, and that we be granted costs and fees on appeal. Thank you very much.
Thank you. Excuse me. How much time does the appellant have?
8 minutes, Your Honor.
Mr. Smith.
Judge, thank you. What I hear Mr. Rowe say is that Philip Weitz, back in 1995, had the implied or the inherent authority, and therefore did exercise that authority, to transfer the stock interests of Dan and John to David. Now, what's interesting is that if that were true, that Philip had done that, then let's look at these meetings each year at Phil's residence every Christmas, when they have their stockholder meeting on IFI and TVM, and they renominate and elect themselves as the directors. Never is one word mentioned by Phil, oh, by the way, Dan and John, I gave your brother your stock. Never happened. Why then, in 2015, in the summer report, doesn't David say that, oh, by the way, our father gave me your interest way back in 1995? We don't see that. Instead, he's trying to buy it for pennies on the dollar. In 2013, after the father dies and they have the meeting the next day at the house, Why doesn't David say to John and Dan, oh, by the way, our father gave me your stock? So there's no reason for us to have a decision on who's going to be in TVM and who's going to run IFI, because I own TVM and you don't. That wasn't said. They have their meeting. They agree. Dan runs IFI. David continues to run TVM. So look at the stock certificate. If Mr. Rowe had a stock certificate that Phil had transferred his son's interest, Daniel and John, to David, where is it? It doesn't exist because it never took place, because Phil never did that. Phil was the patriarch, yes. He orchestrated who did what in the respective corporations, who went where, and he told everybody what to do, but he didn't steal their interests. In fact, Phil gave the sons his interest in IFI. They ultimately became the sole owners of IFI. So if we were to accept what Mr. Rowe is saying, that, hey, let's look at it this way. John Tavares and David Weitz ran TVM for 15 years, 20, 25 years. They're the ones that stood out there in the cold. They are the ones that did the welding. They did all that had to be done. Therefore, they must be the owners. Well, if that's the case, if that's the logic that Mr. Rowe is going to use, then what about Idaho Farmway? We don't see John and David over there participating in Idaho Farmway. It's Dan Weitz running Idaho Farmway for 15, 20, 25 years with no help from his brothers. So is Mr. Rowe going to give Dan Weitz IFI? I don't think so. That's owned equally 1/3 each, just like TVM. Now we get to the idea, Mr. Rowe was mentioning, well, Dan doesn't have any certificate of stock. We got it. That's correct. Dan issued the 3 certificates in 1987, March 3. Placed those 3 certificates, 25 shares each, in the corporate file. David took that corporate file after the meeting on March 25, 2013, along with many other files and documents and gold and silver and cash. So that's where it is. And so they've got certificate number 1. That's true. It's in the file of TVM. They've got certificate number 2. That's true, in the file of TVM. They got certificate number 3. That's David's certificate. And he produced it, a copy of it to us in August in the summary report 2015 to confirm, hey, I got this interest. Why didn't he then say, you guys don't have an interest? Why is he offering him money? And most importantly, Your Honors, you don't give John Weitz $2.1 million because you love the gentleman. You give him $2.1 million because you just bought out his equity interest for half price, less than half price. And he walked with that because he was broke and he needed money. Now we talk about who financed what. IFI, owned by the 3 brothers, financed TVM in its startup years, clear through 1995. That's where it got its money to buy equipment, machinery, land. Came from IFI. Who owns IFI? The 3 brothers. Dan Weitz contributed to the financial development of TVM. Didn't run it, but he financed it. When Dan sold Ace and Superior Steel in 2001, he brought over $750,000 of equipment and materials. Where did it go? It went into TVM. Who wanted it? His father wanted it there. Dan agreed. So Dan's financing TVM to the tune of almost another $1 million. So to hear Mr. Rowe say, oh no, Dan had nothing to do with TVM, excuse me. He financed it out of IFI. He financed it for $750,000. He met with the brothers and he was a stockholder and he is the director, always. And I talk about tax returns. Yeah, tax returns are in the file that David has, but we found copies of 3 years. 3 years ago into 1995, the year Mr. Rowe said, oh no, Phil gave all that stock to David. Sorry, Mr. Rowe, those tax returns, and they're in the record, demonstrate when they were filed that the three brothers owned TVM. Those records for 1993, 94, 95, and 96. We don't have the others. David has them. We found out in 2015 the equity value, yes, it's significantly increased. You finance it with IFI funds and with Dan's funds out of his other corporations, it's going to increase, and it significantly did. I believe that's sufficient, Your Honor, with my response to what has been stated. We rely upon the record. If you review that record, I believe you will find there are genuine issues of material fact that require reversal of this decision. Let's go to have a trial. We'll test the credibility of these wonderful witnesses that spoke badly about their brother. They each speak badly about each. That's a fact. Thank you.
Thank you, sir. This matter is now under advisement. We'll render a decision. I thank both counsel for their help today. Court's in recess.